Court is now open. You may be seated.
Mr. Harrington?
Good morning. May it please the Court. William Harrington for the defendant. The first issue is whether or not the trial, the motion judge erred in ruling that there was probable cause to arrest. And just briefly, the facts in this case, based on the motion hearing, was that there's a Boston police officer undercover making observations at 10:15 in the morning in the Roxbury section of Boston at a place that he had, well, in that general area, 10 to 15 drug arrests, I think, in the previous 3 months. The officer had only been in office for about a year. He observed my client with another gentleman named Neil Hassett walking in front of the supermarket. In this area, the testimony and the finding was that it's a heavy pedestrian traffic, heavy vehicular traffic. Walking, then they walk down a side street, talking, having a conversation. At some point, my client was standing in the street, had his left foot up on the curb, reached down. It appeared like he grabbed something. The officer didn't say that he saw an item, but it looked like he grabbed something, handed it to Mr. Hassett. Didn't appear that Mr. Hassett gave anything back. Then they both walked away. My client was walking back up toward the intersection. At that point, the officer...
drug transactions in this area, were there not?
The testimony at the hearing was that, in general, the officer had knowledge that other officers had made other drug arrests in that area.
I thought this officer had been staking out that area for some time and had made some 15 arrests in that very area.
Yes, and he testified that in the previous 3 months he was in that area, and he had made 10 to 15 arrests for heroin in that area. So there is, the officer isn't that experienced, but he does have some arrests in that area. It doesn't describe what area it is, but just the general area.
Why can't he, knowing that it's a kind of a little bit of a beehive for drug activity, walk over and, having observed what appears to him to be a drug transaction, walk over to the fella, show his badge, and say, I want to talk to you for a minute. And then the guy runs. Isn't that what happened?
Yes, he did. But
so the first thing is a Terry stop. Really, it's a Terry stop.
It's a Terry
there
stop.
is a, I would submit that was a Terry stop at the beginning.
An attempted Terry stop because the guy ran.
Yes. Though the defense counsel never moved for suppression on the basis of a Terry stop. He moved to suppress on the basis of the arrest, the grabbing
But I'm
of him.
suggesting it's a permissible Terry stop that later ripened into probable cause when he ran, started running.
And the motion judge agreed on that latter point. The first point the motion judge didn't address because it really wasn't an issue. My argument is that there wasn't a probable cause, even though there was flight. Obviously, flight is suspicious activity, but the case law makes clear that flight alone isn't enough for probable cause. In taking away the evidence of the flight, here, for one, the officer doesn't see anything. I understand that drug transactions, things are small.
Well, he saw something. He saw him put his left boot on the street and take something out.
There's no
So
description
you
of
can't say
any...
he didn't see anything. He saw what looked to him to be a drug transaction.
Okay, I think the testimony was he reached down, grabbed something, and handed it to. But there's no description of what object he saw
How
or
can
whether...
you distinguish this case from Commonwealth versus Santa Liz?
Santa Liz was different in that I think that case dealt with a cab pulling over and the defendant going to a person next to him, this person reaching into his belt, handing him an object, handing it into the cab, the person there giving money, seeing money going back. Here, if Mr. Hassett, if it was a drug transaction, the officer doesn't see Mr. Hassett give anything to my client.
He doesn't have to. It could still be a one-way transaction. Maybe he paid him a month before.
Perhaps
he took it out of his boot. There's something bizarre about that. That's what really caught his attention.
I understand, but I think that the lack of any evidence of a transaction, an exchange, it was a one-way exchange, goes against the suspiciousness of the activity. And here the officer testified at the hearing he was not familiar himself with any transaction being done on credit. That was his testimony. So the evidence at the hearing was that perhaps there was an item going one way. It wasn't described. It wasn't
That's all you need for a drug. All you have to do is distribute it. You can give it away. You don't have to get money back.
I understand. But the suspiciousness of whether, in fact, what he's observing is a drug transaction, the fact that this person who's getting it isn't handing something back. I mean, if the other person's handing cash back, that would make it even more suspicious. Here, there's no indication this person receiving the drugs is handing anything back. And I would think that lessens the suspiciousness of that observed conduct. In here, there's no, in Santa Liz also, I think there's no conversation at all, and that added to the suspiciousness. Here, there's a conversation. They're walking down the street, talking. There's very little testimony as to how long the conversation was, but the conversation was they're walking. It's a very busy place, perhaps certainly an area of high drug activity. But I mean, they're talking. It's right in the public, high vehicular and pedestrian traffic. The fact that you're having a conversation, certainly, I mean, Roxbury, this area, the testimony was that there was drug incidents, but certainly this is just obviously could have been just an innocent conversation. The fact is he reaches down to his boot and appears to hand something from there. Is that enough to stop someone? I mean, that's the question.
At what point did the police officer testify that the defendant threw the object? I have not read the transcript, so I'm not clear
The testimony at the hearing was that after the officer grabbed him, there was some struggle, and the defendant was filling his arms.
Okay, so it was after the grab.
But there's no testimony of him ever seeing any object being thrown. At trial, there was testimony after he was grabbing him. He saw an object being thrown. But at the hearing, for this issue, there's really no testimony. But I think the only inference you could raise based on the testimony was that it was after he grabbed him. The second basis of the judge ruling said there's no standing because he found it under the car. I think the judge was wrong on that, in that, consistent with the Commonwealth's theory, they're alleging my client possessed the drugs. And my client isn't obligated to admit he possessed the drugs. In here, consistent with their theory, he had the drugs at the time of the seizure. And if I think the case law is clear, if the drugs are discarded as a result of an illegal seizure, they have to be suppressed. I think certainly on that second point, that the motion judge was incorrect. On the first point, my argument is flight alone isn't sufficient. If you take away the evidence of the flight, the evidence is not consistent with a drug transaction. Given no items ever seen or identified, there's not a two-way transaction. It's in broad daylight. It's in a heavy pedestrian area. There's no indication that my client or anyone else is looking around in different directions. I mean, so based on that, I argue that there was not probable cause enough to arrest.
If we adopt your position, then it would be almost impossible to establish a sufficient basis for a threshold inquiry from witnessing a drug sale, because you're not going to see much more.
Well, there's
What
cases
can you
where cash is exchanged, where people are looking around. There's almost a lookout. Here, where
No, but if you don't actually see the cash being exchanged.
Well, I mean, there's every case has various factors, but here is just a conversation in front of a busy store, walking down the street, and someone reaches down to his shoe area, then appears to hand something. Does that mean that's a drug transaction?
But they turned down a side street, didn't they?
There's a side street. There's no the only evidence at the hearing. I think that the testimony was that intersection was very busy. At trial, and I know it's not relevant, the testimony was both that street and the side street had heavy pedestrian traffic. But at the hearing, there's no distinction between any traffic on the side street and the main street. There just wasn't. The only description, I think, was that this intersection had heavy pedestrian and vehicular traffic. So to describe it as a side street, maybe that's correct, but I don't know if you can infer from that it was more less conspicuous than that going down that street. And certainly that wasn't the case at trial, that it appeared to be the same. Again, my argument is that there wasn't enough probable cause to arrest here, and the motion judge was incorrect. A related argument is that the defense attorney should have attacked the initial threshold stop, because by doing that, he could have gotten rid of the evidence of flight from the court's analysis. Also would have avoided any issue of standing. That would have gone away. and it would really have focused on whether that was a threshold inquiry, whether that was enough suspicious facts. Because certainly I think the evidence of flight probably is the most damaging to my client. That would be out of that analysis for a threshold inquiry. I think the Commonwealth would argue that that encounter does not arise to the level of a seizure under the Fourth Amendment and under Article 14. I submit that it does, where there's an undercover officer, he approaches him, displays his badge. But secondly, on that point, that issue wasn't really developed at the hearing as to whether that was a seizure, because it wasn't a live issue. And if the court does agree that that was ineffective, I'd ask for a remand for further evidence.
Well,
on that.
let's assume we conclude there was reasonable suspicion such that a Terry stop would be warranted. I mean, a Terry stop is a sort of a seizure, isn't it?
Yes.
Temporary seizure.
It's a seizure for Fourth Amendment purposes. And if it was, it has to be justified under reasonable suspicion. If the court were to agree that there was reasonable suspicion, I'd lose on that as well. But my argument, and the similar argument on probable cause, is, again, for reasonable suspicion, you would, in this instance, take away the evidence of flight, and basically all the other factors are there that I already argued about. That
there's no question you'd have to take away the evidence of flight.
Yes. And so that's why I think that's the benefit of making that argument, and really there's no downside for the defense counsel not to have raised that. Because
don't we have a lot of cases that say merely identifying yourself as a police officer is not a stop?
Not a seizure.
there are
He may
cases.
have intended to do a stop, but he didn't get very far.
In this
and
case,
merely saying, show me your badge, Boston Police. That's all he did. Could be Boston Police. Do you mind speaking with me for a sec?
Your Honor, I think I'm relying on a general principle. In some of the cases, the facts are similar that wouldn't help me too much. But here, that issue, if that's a live issue, I'd ask for further evidence, because on the issue of whether that encounter was a seizure wasn't a live issue given the defense counsel's theory. It's just that there wasn't really testimony developed at the hearing as to how fast was the officer, how loud did he speak when he said that, what was his tone of voice, how was he displaying the badge. But I do think that here, if he wants to talk to the defendant, why does he need to show his badge? Why does he just walk up to him and ask him? Why does he need to show that he's an officer? Obviously,
because
I think
he's not wearing any uniform or anything. He's wearing a hood over his head. He's trying to blend in with the people in the area.
Oh, I understand.
So,
But I think
A strange person walks up to you and says, what were you just doing reaching down into your boot, is different from knowing that it's a police officer asking you, I'd like to know what you were reaching for down in your boot.
And I would agree. And I think from a reasonable person perspective, if a police officer walks up to you, you feel compelled to stop your movement and
But our
and
cases
respond.
say otherwise.
Your Honor, my main point is that the record on that issue is undeveloped given the failure of the defense counsel to raise that at
But
the
whose
hearing.
burden is it to raise that issue below if we were to decide this case on the basis that the police officer's identification of himself as a Boston police officer did not initiate a threshold inquiry?
And you say, it's ineffective assistance of counsel.
It's ineffective assistance. That the defense counsel should have raised it, that the lack of raising a viable claim is ineffective assistance. Here, it's not as if he's making a decision during trial. He's making a motion to suppress. Why not raise an alternative basis where clearly you're removing the most damaging evidence against your client by saying...
Right, but you're raising this ineffective assistance claim as part of your direct appeal, correct?
Yes, I am.
Without any record on a motion for new trial to indicate this sort of speculative, well, if there'd been a hearing, I would have been able to adduce the following, the defense would have been able to adduce the following facts. That needs a factual record that we don't have, doesn't it?
Well, I understand that ineffective on a direct appeal.
Needs a motion for new trial with some affidavits and things that indicate that there really was something to this potential motion to suppress on a different ground. Don't we need that?
Well, there is... I understand that for a direct appeal it's tough for ineffective assistance, and there's no supplementation of the record because there's no motion for a new trial. But I do think even on this record, and I know that the case law here may go against me to some extent, but a police officer approaching, saying Boston Police, showing his badge, who's undercover, wearing a hood, I think from just the general principle that stated in the cases of a reasonable person, a perspective of a reasonable person, would a reasonable person feel compelled I would say there is, and I think the court could rule as a matter of law. Perhaps you'd have to alter some previous rulings, or you could, if the issue was serious enough, that you could remand for a new hearing. But you're right, Your Honor, there is no supplementation of the record on that point. There's also an ineffective assistance argument, my third argument, my last argument, in that here a real issue, at least a practical issue in the case, is the sentence. And here there's possession. I see my red light's flashing, but I'll try to.
You may finish the sentence.
Okay. The ineffective assistance. Here, essentially, counsel conceded intent to distribute. Here there's only 30 bags of heroin. The testimony by the expert, by the Boston police, was that a user could use it in one day. The defense counsel never cross-examined him, never raised up in closing argument. I think consistent with his theory, he could have supplemented it with, you have to find every element. Why not here, even if you found possession, it's just straight possession. That would have had a huge impact on my client's sentence. And if there's no questions from the court, thank you.
Thank you, Mr. Harrington. Ms. Lovell?
Good morning, Your Honors. Amanda Lovell for the court. With me is trial prosecutor William Freeman. If it please the court, just very briefly on the facts, the testimony at the motion to suppress hearing was that the defendant and Mr. Hassert were in front of the supermarket and then went down the side street, which is described as the street that runs alongside the supermarket. So there's certainly a fair inference there that they're going from a more public place to a less public place, and that is fairly considered into the furtiveness that is then, of course, very much magnified when the defendant reaches into his shoe to pull out the item. With that, the officer does see that that the handshake from there, that is very close to what this court found to be probable cause in Santalese and in Kennedy. And as Judge Spurlock recognized, it isn't quite as strong. There are a couple of factors. In Kennedy, the people were known to be...
Probable cause or reasonable suspicion. What are we doing here right now?
Judge Spurlock found that was probable cause.
And what do you say?
I'm sorry. Judge Spurlock also included the flight in the probable cause analysis. I would say that before you include flight, you've absolutely got reasonable suspicion. There's no question, and I would rely on Alvarado for that, where a police officer merely seeing an individual tucking something that looked like something that drugs were packaged in, but not actually seeing what the thing was. It's seeing like a corner of a glassine bag.
What do you say on the no threshold inquiry question? What do you say on the no threshold inquiry issue?
We never reached a threshold inquiry in this case. I would say that the officer was intending to do that. He had plenty to do that at the time when, with what he had seen at that point.
But what about the fact that his just going up and saying, I'm Boston police officer, I want to talk to you? Is that a seizure?
No, that is not a seizure. That is just simply a reasonable thing to do in a neighborhood where, as it's been suggested, a person approaching you, you might not want to talk to that person.
And in any event, if he did not do that and said, what just happened? And the defendant said, I just sold a baggie, do you want one? I mean, the defendant would be in here screaming, saying, you can't do that. You've got to identify yourself as a police officer.
That certainly raises a whole different set of issues.
Sure.
And for whatever small relevance it has, Officer Figueroa testified that he was in plain clothes but not undercover. He was not functioning as somebody who was trying to buy drugs that day.
Okay, so you have reasonable suspicion to make a threshold inquiry. It never happens because as soon as badge is taken out, defendant flees.
Exactly.
Now what do you have?
Now we're clearly at probable cause,
Okay.
and that's taking Santalese and Kennedy and adding flight.
Out of curiosity, let's assume all of the facts here. Defendant is arrested. No heroin is found, however. Is there probable cause to bring a complaint for something in particular here?
Well, certainly there's a fair inference of assault on a police officer. The flailing that he does during when the police officer's attempting to subdue him.
I was just saying that you say there's probable cause to arrest, but if in fact that's true and the arrest had been made, now what do you do with the case? Is it probable cause, sufficient probable cause to bring a complaint, criminal complaint, and for what?
If you find no drugs, I mean, there were also, are we also taking away the two
Yes.
drugs that were found on the?
Correct.
Okay. I would say it's not a case that could be proven if there are no drugs.
And here, it's the Commonwealth's position that the drugs that the police officer did see were in plain view?
Yes. Yes, they were scattered around and somewhat underneath the car, and the defendant is actually...
Well, at that point, they had been abandoned as well.
Well,
But he's got to link them to the defendant.
based on the evidence that came out at the motion to suppress hearing, there is no evidence at the suppression hearing about when those drugs went under the car. At trial, there is testimony that
But
something is thrown during
We're
the
not a
flailing.
motion to suppress, right? So it's what's at the motion to suppress, correct?
I understand, yes. We have not advanced the argument that Judge Spurlock, his alternative argument that the drugs were abandoned, because there is subsequent evidence that suggests, that demonstrates that the defendant possessed the drugs at the time that the stop occurred.
These
And-
drugs were in the location where the defendant and the officer were flailing about.
Yes. Yes, the defendant is basically subdued around the backside of a car, and the drugs are found in the vicinity and underneath that same car.
This sounds like an odd question, but let's assume that you almost have reasonable suspicion. You certainly have enough to go up and ask some questions. Let's not call it a Terry stop per se, but certainly just an inquiry. And then there is a run, and maybe that gets you reasonable suspicion to...
Stop
Is it
the-
possible that it could give you less than probable cause, but reasonable suspicion to stop the person?
Well, certainly, an individual can't avoid being questioned if there's reasonable suspicion, if there's
Right.
enough for a threshold inquiry.
Maybe let's go to that. Reasonable suspicion, you approach, person runs.
That can, the answer cannot be that if the person runs, then they don't have to submit.
So you have to be able to seize them in some fashion.
Yes.
At that point.
Yes, and it would be a lesser seizure than you could do if you had probable cause. But it would, a
You could
short
say stop.
seizure. Yes,
And
you
if
could say
somebody-
stop. I think that you could actually put your hands on the person.
No, you can say stop, and while you're running, I'm sure you are saying stop, although there doesn't appear to be evidence of that here. And then you,
Well, in
Grab
fact,
the
as soon as you give flight,
Here, I got it, the flight was extremely brief.
Yes.
yeah, a few feet.
That's right.
But
Yes.
presumably, ordinarily, as soon as you give flight in an effort to stop someone after you know that they know you're pursuing them, that is a seizure.
Well, I think the case law is specific that if the person flees first, that this is, and let me take back if I just said that it's clear. I think it's not entirely clear. It seems clear that that pursuit that is not known by the person being
Of course,
pursued
but
is not a seizure.
I'm a police officer, and you take off, and the police officer then begins to pursue you. That's pretty much a seizure. Chase you, not...
Well, yes, I think if it's in response to the, I'm a police officer, but if the person runs, or if it's in response to stop, I'm a police officer, and the person runs, then it's in response to that stop. If it's in a case like this, where the police officer was doing what any individual who is not a police officer has the right to do, walking up to somebody and talking to them, and the person runs, there hasn't been any constitutional seizure at the point when this defendant runs. And so
But-
at that point, it's not
But
clear.
no, it's not when they run, it's when you pursue them.
Well, it's not clear that pursuit that
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 the
is not
flight gives you
initiated.
probable cause
yes.
to arrest.
Yes, I would say that, yes. But I'd also say that
Or reasonable
simply
suspicion to
following-
stop.
It gives that also. But it's not clear that following the person who is running away from the police officer, when the police officer has done nothing to restrict that person's movement, that is pursuit. Certainly if there is a command of stop and then there's flight, that's pursuit. If there is running and without knowledge that the person is being chased, which I think is Perry, that's not pursuit. Exactly when pursuit starts, if the person is aware that they're being followed, but the following is in response to the running as opposed to the cause of the running. I don't think the court is entirely clear on that point.
But a person in the objective circumstances of this defendant, after he flee, does it make any difference in this case?
It does not. Nothing happens during that period of time. There's nothing else to add to the reasonable suspicion or probable cause.
On another subject, was there a limiting instruction at trial about using the cross-examination of Detective Figueroa about his police report only to impeach him and not for substantive purposes?
I believe there was, but I don't recall. I would have to
Well, he got
check the record.
there was a contradiction in the police report with Figueroa's testimony.
Yes.
And there was a claim of ineffective assistance of counsel based on the failure to cross-examine. But he got the information out from a different police officer and was able to parlay that into an inconsistent statement, better than an inconsistent statement.
Yes.
He claimed that Figueroa was able to change his testimony to tailor it to the case.
That's right. He used it substantively in his closing argument to argue that Hassett had been the one who had thrown the drugs, that the drugs had belonged to Hassett and not to the defendant. If the court has no further questions, I would rest on my brief.
Thank you, Ms. Nolan.
Thank you.